Perfect. Thanks so much, Martin. Well, it's an absolute pleasure to be here. I'm joined here with Roy to kind of explain our templates, what we've been doing. By way of overview, um, this is myself. I'm an associate on the Dentons planning team, and I'm joined here by Roy Pennick, who's the head of UK planning at Dentons. I think just for an overview of today's session, we'll give you a little bit of introduction into who we are and how we got involved in creating these templates with the Planning Advisory Service. We're going to go into how the templates were created and a bit of that process, and then we'll discuss the applications of how to use the templates. So, this is not a session where we're going to share a screen or give you an entire overview of the biodiversity net gain regime. Really, this is about looking at what are the requirements and issues that you might encounter and how the templates can be used as tools to help solve those problems. We have a Q&A session at the end, so please do pop any questions in the chat and we'll deal with it at the end of our presentation. By way of creating the templates, it's good to talk about how we got involved, and I'll pass over to Roy on this.
Thanks very much, Grace. Great to almost see you all. My Teams isn't working very well at all, and I've got a black screen. I can't see anything. Fortunately, not myself, but also can't see the slide deck or anything like that. So as long as you can hear me, that's fine. I'll just rely on Grace to tell me when the next slide is and all the rest of it. But I think first slide, why do we get involved? There's a sales pitch on that slide, so I'll skate over that. But fundamentally, we advise the government, we advise local government, and we work with developers, investors, strategic land developers. And as part of all of that, we could see coming down the track that there would be a lot of complexities, but a lot of scope for solving problems and sort of rising to the challenge that the regime would throw out there. And so from our perspective, it's as a matter of curiosity, it's a great thing to have been able to assist PAS with this work. And I think to the points that have just been made, it is the first step. So we'll come on to some of the core principles of the work that we've done and what's guided that. But I think the core reason why we got involved was to try and set the stage a bit with something that's brief, simple, clear and accessible, that can both be usable where there are schemes and habitat banks that can draw down on them today, but also to provide a clear and sensible basis for debate and dialogue about other things that should be bolted on, and some of the greater levels of complexity which will be layered in on schemes that are phased, on schemes that are much larger and longer term. So for us, it's about sort of foundational dialogue and curiosity, and we'd seen some of the slight oddities that were creeping into some of the BNG dialogue, if you like, on some planning appeals. We've been involved in judicial review proceedings involving BNG, which we helped to win with our client, which Grace was involved in. People beginning to negotiate those option agreements or agreements for purchase of BNG units, and some of the challenges, oddities that were creeping into those, the slight disconnect between those and that actual expectation of what the planning process needs or actually does. And that was during the transitional regime. And then the interaction with the other side of BNG, which is much more about planning merits and EIA kind of mitigation rather than the statutory scheme itself. So trying to bring those things together and provide something that is user-friendly, accessible, and flushes out some of the discussions that we need to have was really the reason why we got involved with PAS. So if, Grace, you could advance the slide, that would be great.
Yeah, so that's up. So that's R&D and inconsistent practices.
Thank you. So I've talked a bit about that, but where we started from was before we were asked to do the work by PAS, accumulating our own overview of what the market was doing insofar as we could, a bit on the habitat banks, a bit on what people were doing unilaterally on development projects, and how the planning inspectorate were dealing with things in planning appeals. And again, that was during the transitional period where BNG was being secured as a merits-based part of the overall offering of proposals, and trying to then look for patterns in that, look at areas where we would want to drive improvement, where we would adopt our own internal template, both for authorities and for developers. And some of the things that came out with that was that there wasn't a great deal of consistency between some of the practices in those documents, that some of them were without being pejorative at all, there's a risk that documents can be complicated to use, without being a lawyer, and even as a lawyer, often find them more confusing. So the core purpose, really, I think the mission of the work is about saying, well, how can we create something that tries to identify consistent practice and make sure that you've got a suite of documents which you don't need a lawyer to operate, which is ultimately, I think, the benchmark test of any decent piece of legal advice, which is at the end of the day, you don't need a lawyer to then give effect to it. So that was really where we were coming from, what we've tried to achieve. It'd be very interesting to hear from people on the call how far you think we've got there, and what we need to do better in order to achieve those goals, because I think they're good benchmarks to have and should be challenging in their own right. But if I hand over to Grace to now tell you a bit more about the detail.
So Roy spoke a little bit about the need and what our approach was. In speaking with the Planning Advisory Service, I think there were 3 key scenarios that we wanted to address. So the first is things that you would kind of just find in practice. Developments delivering BNG on-site only. Then you might have a development that's delivering BNG on-site and off-site. And then you might also have a habitat banking arrangement where, completely independent of development, you're going to carry out some habitat enhancements on land and seek registration. So the template really is, the templates that we produce are essentially like a toolkit that can be applied to these specific scenarios. But it is worth looking into what were the challenges, decisions, and the solutions that we adopted, and that will give you a really good shape and understanding why the templates take the form that they do. So in terms of challenges, these templates are not intended to set out policy. So while there are many different ways to secure biodiversity net gain, they're not pushed forward as this is the best way or the only way in which it can be done. This is a starting point. It's an example. It's supposed to be tailored to specific requirements of the development or the land. There are also multiple development types and scenarios. So these are good for medium-sized development. You could take a lighter touch approach for smaller developments, but providing templates of this flexibility, I think, and optionality gives you the options of dealing with multiple different development types. One of the decisions was to include that optionality, but not extend it to phase development, for example, because you're dealing with quite a lot of complexity, for example. And then one of the challenges that Roy touched on is this is all, Roy and Martin touched on, these are both, new areas. During the transition period, they didn't really want to continue in the same trend of making it highly complex and very difficult to navigate. So our decisions and what we chose to kind of bring the ethos into are those templates is to adopt a plain English approach. Our approach is also condition first. So anything that can be dealt with by condition, especially in relation to a development, we're going to be doing that by condition. We're only going to be looking to planning obligations where it was necessary to do so. And one of our approach, which I think bleeds across all the documents, is securing BNG as business as usual. So we try not to reinvent the wheel, although there's a new regime. If we can secure BNG in traditional ways without adding in unnecessary complexity, that was something that we absolutely wanted to prioritize. So in terms of the solutions and kind of the outcomes of that thought process, there is some optionality in the templates, but they don't cover all scenarios. And then there's drafting notes on options. So you can just work your way through all the documents from start to finish, and it will flag to you where there's an option or something's not legally required, but it's included in the template. You have enough information that it's brought to your attention, and then you can make the decision about what needs to be included. So the templates, when you think of the toolkit and those 3 scenarios, you have 4 resources that are available to you. The first 2 should be treated like a pair. So the first is the condition to secure on-site BNG for non-phase development. The template for the condition also includes our interpretation of what the statutory condition is. It's there just purely as an informative, but it's not there to suggest that you apply that or put it into your decision notices. That condition secures the ongoing maintenance and monitoring of the on-site biodiversity net gain. It can also be used in conjunction with a Section 106 agreement to secure a BNG monitoring contribution. So those two together would kind of be a package that could be applied to development securing BNG on-site only. Now, if a development is looking to rely on on-site and off-site biodiversity net gain, keep in mind the new regime requires that all off-site biodiversity enhancements be registered on the biodiversity gain site register for it to be included in a biodiversity gain plan, right? So that's the discharge of the statutory condition. For that to be registered, it needs to be secured by legal agreement, whether that be a Section 106 agreement or a conservation covenant. So we provided a template that secures the on-site and off-site obligations. This is specifically, think about a scenario that benefits from the imposition of a condition, right? Because it's connected with the development. You can have a condition that secures all the on-site gain. However, anything off-site has to be tied and secured by that Section 106 agreement. You can't take the on-site BNG condition that we've provided and apply it to off-site gain and then try to register that. So this Section 106 agreement includes the concept of a development and planning permission, and the monitoring contribution secures the monitoring of obligations pursuant to the deed, right? So under the Section 106 agreement, and it also includes the monitoring of obligations of the condition that's applied to the development. And then the final one is a Section 106 agreement that just secures habitat enhancement and creation works offsite. So it's not in conjunction with any development. It's completely independent of any particular planning permission. It is just enhancements on land that you can take for registration. In terms of, I think it's worth kind of discussing a bit about the feedback and the responses we received in the drafting process. So we produced some initial drafts, and the feedback that we received from the Planning Advisory Service was to include more optionality. So instead of stating how monitoring key contributions should be indexed or how often they should be paid, it really was just about flagging to anybody reading the templates. There is an option here that you can make. Have a think about what you want, and then amend the drafting to reflect that those decisions. And we also needed to avoid setting any policy positions. So things that we thought were robust or really great ideas actually would be kind of a step too far in terms of what the legal regime actually requires. So that's reflected in our secondary drafts, which really responded to that feedback. And it was really clear that because we were dealing with multiple scenarios and options, we needed to include more drafting notes as a result to kind of explain how someone reading these templates would be able to navigate the regime and understand, am I actually using the right tool for the job? What options should I be including in these agreements and conditions? We also received some feedback. So as you'll see that Alexa is on this call, so the Environment Bank had some fantastic feedback. MHCLG also had feedback as well. That was across the conditions and all three Section 106 agreements. And we were very grateful to have that feedback. I think it's a complex regime, and having multiple pairs of eyes and different stakeholders involved in the feedback process was very helpful. A lot of that was about including additional optionality, dealing with a wider range of scenarios. And our templates responded to those optionalities without just making it completely confusing for someone reading through the template. So hopefully as you're navigating through our tools, you can kind of see how they can best be applied. And then before they were issued, we included more front-end drafting notes to explain usage and optionality. And I'll explain that in my next section, which is about how to apply and use the templates. Now, I think when looking at applying the templates and dealing with biodiversity net gain, it really is about understanding the development process. So thinking about, what is the new regime actually requiring? What does that look like at the pre-application stage, stages where the permission's been granted prior to commencement, and commencement onwards after the development has been implemented? And part of this is keeping in mind that the Town and Country Planning Act, as it's been amended, imposes a statutory deemed condition on really every single planning permission in England, subject to limited exceptions, that prior to commencement, they submit a biodiversity gain plan for approval. Now, that biodiversity gain plan is informative. It sets out what the strategy is for achieving a 10% biodiversity net gain. So it will set out a quantum for how much is going to be delivered on site, how much, if any, will be off site, the reference numbers for the gain site register for where those offsite units are coming from. It's going to say whether or not the development has complied with the mitigation hierarchy. There's just a lot of information in there. However, that statutory condition doesn't really secure the any on-site works for a period of 30 years. So there was a need here to consider the imposition of a condition that will secure the maintenance and monitoring of on-site habitat creation and enhancement works for a 30-year period. But when considering conditions, I think it is worth at the pre-application stage thinking about what kind of planning application you're dealing with. Is this an outline or is it a full planning application? I mentioned that because something that we've seen during the transition period was treating both outline and full planning applications as the same. So you won't know what your post-development biodiversity value will be until after reserve matters are submitted. So if you're dealing with an outline stage, you have that statutory condition that triggers as a requirement prior to commencement, right? So it's your hard barrier there. But you may not know exactly at pre-application stage what development is going to be, what the on-site degradation is going to be, and how much biodiversity units it will take to reach 10%. So at pre-application stage, always consider what is the type of application I'm dealing with, how much biodiversity gain, if any, is proposed on site. And that should give you more information to navigate that template condition. There's an optionality there for outline planning consents and then setting out optionalities for what a developer or an applicant is going to be submitting for approval. So is that an on-site habitat management and monitoring plan? Maybe it's something else, and it can be something else. It might just be for smaller habitat enhancements, something akin to a landscape ecological management plan. So that was something that we saw during the transition period. It definitely is probably a trend that we'll see going forward. At the planning permission stage, I've touched on this, but that statutory condition isn't going to appear on decision notices, and it doesn't secure the maintenance and monitoring. So our template sets in a starting point and an example for how the 30 years will be, how it will secure the maintenance and monitoring of the on-site biodiversity for 30 years. It's worth flagging that the 30 years runs from completion of development. Completion of development is not a concept which is explained in the Town and Country Planning Act. So it is an opportunity as well to agree what the completion of development may mean with applicants. It could be practical completion, it could be first occupation. We have seen this, we'll probably see additional examples coming forward, but it is worth, I think, explaining what that could be, especially when you have a development that may take a long time to actually be fully completed and built out completely. And as I mentioned before, the prior to commencement, you submit that biodiversity gain plan for approval. It is informative, and it requires that if you're relying on offsite biodiversity units, those units be registered. So you would then consider, do I have a Section 106 obligation to secure those offsite habitat enhancements? At the time that a decision maker is choosing to approve that biodiversity gain plan, you don't need to look at the Section 106 agreement. You can rely on the units that are on the register to do so. But in terms of providing kind of a full solution for these development scenarios, the templates for the Section 106 offsite and the habitat bank show you a pathway on how those units can be registered on the biodiversity gain site register. And then once development is commenced, the BNG on-site will be maintained pursuant to conditions imposed on the development. Anything off-site is just going to be handled by the enforcement powers to the local authority or the responsible body that's entered into the Section 106 or Conservation Covenant to enforce those off-site habitat enhancement works. So in terms of how the templates are used, what I didn't want to do was a long scrolling through of these documents showing the nitty-gritty of everything that's included. It really is just about having your eye on what the kind of developments and situations that could arise and how each one of these tools can be deployed. So remember, the first scenario we considered is a development delivering on-site only. So you would think about casting your eye on the template for the BNG condition and then the on-site biodiversity net gain template. So that on-site obligation only secures the monitoring fee for BNG. Everything else is dealt with by condition because it can be. For a development delivering BNG on-site and off-site, you can still apply the template condition, but you will need a standalone off-site Section 106 agreement that secures all of the off-site biodiversity net gain enhancements. And the reason for that is there are regulations regulating exactly how off-site biodiversity net gain can be registered on the biodiversity gain site register. Everything except notice requirements need to be secured by legal agreement. So the implementation of a habitat management and monitoring plan needs to be secured by legal agreement, and those obligations need to be secured. The maintenance of those works need to be maintained for 30 years from the completion of the works. So whenever you're looking at the offsite Section 106 agreement and the Habitat Bank agreement, please do start with the habitat management and monitoring plan and get a sense for what's in it, because I think they're going to vary quite a bit from site to site. They don't have to, but I think they will, because there's so much scope to include notification requirements or a schedule of notification and monitoring. So it's worth just casting your eye over the plan, understanding what does the plan actually secure? What's detailed within it? Are there force majeure provisions? Is it very clearly delineated within the habitat management and monitoring plan when the works are completed? I think there's a really common misconception that on-site biodiversity net gain is secured 30 years from the date that you start the works, but for off-site, it's 30 years from the completion of those works. And unfortunately, sometimes habitat can take years to establish. So don't just assume that the approach is 30 years. It's 30 years from completion. So look at the habitat management and monitoring plan and be satisfied that you know when those works are going to complete. What you don't want to see is a 30-year schedule and you're not entirely sure when those works would complete, because then you wouldn't be satisfied that the works, once completed, would be secured for 30 years. And this final scenario is a Habitat Bank Section 106 agreement. So it doesn't include the concept of a development or planning permission. It's completely agnostic. And it's worth pointing out that the offsite Section 106 agreement secures habitat enhancements. Although it has this concept of connection with development, it doesn't say that it's going to secure a finite amount specifically for that development. Anyone utilizing that tool is free to secure as many units as they want on that offsite land, and there's no restrictions within that agreement that ties them to allocate all of those units or some of them to a particular development. In terms of features, it is worth running through a bit about the feedback that we received and the creation and development of these resources, so that you can kind of understand why those elements are there. So in the condition, we've got the statutory condition, but that's purely informative. The Town and Country Planning Act doesn't provide a standard wording that says this is what the statutory condition is. We provided our interpretation of what that is, and we reflected on the drafting note that it shouldn't be included on decision notices. But I think it's always helpful to look at what's secured under statute, so that when you look at the optional condition that you will impose on decision notices, you have a really good, clear one-page view and as to how those conditions will overlap. Our drafting notes also reflect what's legally required versus duties on local authorities. There's a duty on local authorities to be satisfied that the on-site biodiversity gain will be secured from 30 years from the completion of development. That doesn't necessarily snake its way into the statutory condition, but it's there to understand that taking into a holistic view in terms of what are the responsibilities when discharging that condition. So really, what does it need to demonstrate and fulfill versus those optional condition requirements to secure biodiversity net gain, you have a clear, one-page picture explaining, how to secure biodiversity net gain on site. In terms of the on-site Section 106 agreement, there's some optionality here on indexation. The template could have been amended to have a pro rata indexation in year one and then align all of those dates on a particular date. We understand that as it's currently drafted, it just has like a standard indexation, but that might be burdensome. Definitely the position on indexation in the on-site Section 106 agreement is not the only way that you can secure a BNG monitoring contribution. If it's easier for your local authority to align indexation across your planning obligations to one particular date, by all means do so. I think that's actually a really good idea. For the offsite BNG Section 106 agreement, you might be wondering, why use this agreement over the Habitat Bank agreement? And it's worth pointing out that the offsite Section 106 agreement, the monitoring contribution will secure monitoring fees pursuant to monitor compliance with the deed, so the obligations within the Section 106 agreement. But it also secures the monitoring of compliance with a condition that's imposed on development. So it avoids the need to have two separate Section 106 agreements. If you have an applicant who says, I'm dealing with an outline planning permission. I don't know what my enhancements will be offsite. I don't know exactly what land I might use that's in my Blue Edge land for offsite enhancements. They could just amend, you could just have a standalone Section 106 agreement for the on-site and then choose later down, once reserve matters are submitted, to enter into the Habitat Bank only agreement. However, that offsite agreement is a really good option for applicants that know at the point that consent is going to be granted what their strategy is for securing on-site BNG. And if they're going to be using some offsite land and they know that they're going to have an excess and they'll just allocate to themselves whatever units they need, you can rely on the Section 106 agreement. So it's just an additional option. And we decided not to include that within the Habitat Bank agreement, specifically because it was just easier for someone to pick up a standalone tool that was specifically tailored for a scenario that would come up often. That way we weren't just muddying the waters on our templates to just have an overwhelming amount of options available. It does not include an option for first allocation. So a developer who's using an offsite Section 106 agreement doesn't have to allocate back to themselves the units. And the reason for that is because you might be dealing with outline schemes where you may not know exactly how many units would need to be secured or allocated to the development itself to achieve 10% biodiversity net gain. So I think that gives you, when you look at the offsite Section 106 agreement against the Habitat Bank agreement, there's a lot of overlap. It's just that this particular template is really well suited to developments that will secure on-site BNG and offsite in connection with a specific development in mind. In terms of the features for the Habitat Bank agreement, it is worth flagging that there's an optionality for who's carrying out the works. So there's a concept of the freeholder. You may have a leaseholder there who is just a gain site operator. So that's someone who's on the land, has a sufficiently long interest in the land to be carrying out those works and delivering the ongoing maintenance of those works. It's an option. It's not necessarily something that you have to do. You may have a freeholder or a developer who owns the Blue Edge land. They're just going to enter into the Habitat Bank agreement. So as you kind of work through the template, every time that you see gain site operator, it will just tell you, it will give you the wording in square brackets, and you can just strike out what's not appropriate or what doesn't really reflect the parties to the agreement. We also have the optionality of mortgagee. So our approach, as you recall, was going to be securing biodiversity net gain as business as usual. So normally you would expect to see mortgagees who, as party to Section 106 agreements, because they can take possession of the site in cases of default, or if they're going to be a mortgagee in possession. So we've included that optionality, but haven't made it a standard. Definitely have a consideration as to whether you think the mortgagee should be a party to the agreement. But in terms of kind of common approach to securing planning obligations, they are included in the template. There's also the optionality of a bond, so securing the obligations during the maintenance period and having more confidence that there are funds available in case things should go wrong. So you'll see the optionality for the bond throughout the definitions and in the schedules as well. If you choose not to adopt a bond, you can strike that out. There's also additional note on indexation and whether you need indexation if you are relying on the bond to secure the financial contributions for maintenance. There's also the optionality of a statement of achievability. So this is particularly, this element came from feedback from the Environment Bank, and it's a very good piece of feedback. When you're entering into the Section 106 agreement, you will have to have a view on the habitat management and monitoring plan and be satisfied that those habitat enhancements can be achieved, because you'll be the enforcing body on the Section 106 agreement to enforce those obligations. A statement of achievability is an element where you can require the gainside operator or the freeholder, whoever it may be, to submit a statement from an ecologist stating in their professional view the land and the habitat management and monitoring plan is feasible. It can be achieved on the land. And so that gives a bit of confidence for a local planning authority to know that they're not relying on their own ecological resource and input to make the determination on the habitat management plan. They have that reliance, if it is something that they want, to rely on that statement of achievability from another ecologist to know that they can enter into this planning obligation and it's achievable. And I think I've just had that whistle stop tour, so it takes us to questions.
Okay, thanks, Roy. Thanks, Grace. That's really, really useful. You covered a lot of ground in a very short space of time, so thank you for that. My colleague Rachel is just collating some of the questions from Slido. I'm going to take some questions from the floor, so if you put hands up, that would really help me to sort of put those in order. Just while before I do that, I just wanted to invite Alexa Culver. Hi, Alexa. Alexa was very helpful in helping to produce these templates. I just wondered if you wanted to say a few words.
Yeah, of course. I just really wanted to, congratulate the team really on producing what I think are a really impressive set of documents. And when I had an opportunity to look over them, all I felt I could add was some of our practical experience around.
You've gone on to mute, Alexa, by accident, I think.
I'm back. Am I back now?
Yeah,
so it was a really fantastic set of precedents. I was really pleased to have the opportunity to feedback some of our practical and commercial experience of securing bonds to secure long-term payments, how the parties to an agreement might change depending on whether it's a gain-site operator run habitat bank, and again with the statement of achievability to really add that extra layer of professional opinion that looking at the soil conditions, looking at the hydrology, what is proposed here really is achievable in that professional opinion, and giving an easy way for planning authorities to have that confidence during this very legal process. So I just wanted to thank Paz and the legal team for producing this, because I think this has been a great milestone for BNG implementation and something that's helping massively in our engagement with local planning authorities across the country.